Joe, without any further ado, the mic is yours.
Thank you. I've got a presentation to share. Do I click the share screen button? Yeah. There we are. Can you all see that? Let's get a few nods. Okay, well, so thank you, Mia, and thank you to all of you for attending tonight's session. Just a quick disclaimer before I begin, although I'll be talking about the Genocide Convention and international criminal law, don't worry, you need to study international criminal law or the convention or any of that. This session is designed to be accessible to everyone. So the topics of tonight's talk ultimately comes down to the effectiveness of the Genocide Convention in protecting human groups. As Mia mentioned in the opening, since the Genocide Convention, the instrument designed to prevent and punish genocide, we've seen genocide in Cambodia, Rwanda, Bosnia, Darfur, Myanmar, and at the time of this session, right now, against the Uyghurs in East Turkestan. So the question really is, why has genocide been allowed to occur yet again? And that's ultimately what I'm hoping to answer in tonight's session. Parties to the convention have a duty to prevent genocide where they learn of a serious risk genocide will occur. So where is the Genocide Convention failing internationally? Now, as many of you will be aware, there isn't a straightforward or simple answer to this question. But for tonight's purposes, I'll be looking at the way the convention defines genocide, and in particular, this requirement for specific intent, something I'll come on to in due course. But before we even look at, is it going to go? There we are. But before we even come on to looking at the convention or how it defines genocide, we must first ask ourselves, what is genocide? Now, I want to open this up to you to start with. So if I was to ask you, what is genocide? What would you say? If you could put some answers in the chat box, that would be great. I think I can view it. Oh, I can't see the chat box. May, if there's any in there, do you mind just reading them out? No, not to worry. Okay. So, next slide. So, genocide, for many of us, may seem an atrocious act that's been committed time immemorial. We can think of so many examples throughout history where genocide has. But this, like many things, is a concept, and it was something developed only in the last century. In 1944, a prominent Jewish Polish legal scholar, Raphael Lemkin, Mia mentioned in the introduction, coined the term genocide in his book, Axis Rule in Occupied Europe. I've put his book on the screen there if any of you want to go off and read Lemkin's work. I would recommend doing that because it does really provide a strong basis of understanding the concept. So he coined the term genocide as an amalgamation of the ancient Greek genos, meaning race or tribe, and the Latin side, meaning killing. So quite literally, genocide means tribe killing or race killing. So Lemkin's conception of genocide was an active response to the Nazi atrocities committed during the Holocaust. It was, in Lemkin's view, the failure of international legal provisions at the time that enabled the Nazis to commit the Holocaust with impunity, and such impunity ought to be rectified via a new conception. Indeed, he begins this chapter when he outlines the concept of genocide with the terms, a new term to reflect a new conception. Now, throughout Lemkin's chapter, it's chapter 9 for anyone's reference, he does give quite a detailed explanation and exploration of what genocide is, but he begins by defining it as follows, and I've put the relevant section on the slide for you to see. So Lemkin defined genocide as a coordinated plan of different actions aiming at the destruction of essential foundations of the life of national groups, with the aim of annihilating the group themselves. The objectives of such a plan would be disintegration of the political and social institutions of culture, language, national feelings, religion, and the economic existence of national groups, and the destruction of the personal security, liberty, health, dignity, and even the lives of individuals belonging to such groups. Genocide is directed against the national groups as an entity, and the actions involved are directed against individuals not in their individual capacity, but as members of the national group. Now that's quite a meaty definition, and there's a lot packed in there, but I always find it quite helpful to consider that definition in two parts. So imagine it as having two key essential foundations. The first is the idea of the sanctity of human groups. So genocide was envisaged and conceived to recognise that human groups are worth protection. So the victim of genocide is human groups, not the individuals of those groups per se, but the human group as an entity itself. The second is how genocide can be completed through various techniques. Indeed, in the definition, Lemkin talks about the destruction of essential foundations of those groups, and the lives of individuals are but one of those essential foundations. You know, Lemkin mentions institution of culture, language, religion, and talks about economic security, liberty, health. All of these things Lemkin recognised are capable of seeing a group be destroyed. Now, although Lemkin conceived genocide in 1944 in this book, this was not the first time Lemkin had looked to international law to protect human groups. And in 1933, Lemkin submitted proposals at an international conference in Madrid, and he proposed two crimes, and I put both of those crimes on the slide, one being barbarity and one being vandalism. Now, the reason I bring these up is because in Lemkin's work, he states that both barbarity and vandalism amount to this new concept, genocide. So both of these crimes, or proposed crimes, amount to the concept of genocide. So the first is barbarity, which Lemkin defined as the oppressive and destructive actions directed against individuals as members of a national, religious, or racial group. And vandalism, the malicious destruction of works of art and culture belonging, because they represent the specific creations of the genius of such groups. So you're seeing both this physical and non-physical side to human groups, culture and the individual lives in physical form. There we go. Now, one thing to quickly add with genocide is that it was also filling a gap in international law. And this was Lemkin's principal criticism of international law at the time. And on the slide, I've referenced one of those laws, and that is the Hague Regulations of 1907. So the Hague Regulations were seen as these pivotal humanitarian provisions, and indeed they were at the time. But Article 46 mandates that belligerents must respect family honour and rights, the lives of persons and private property, as well as religious convictions and practice when occupying the territory of another state during times of military conflict. Now, they are, of course, humanitarian provisions, and often throughout occupation, you're looking at protecting usually minority rights under this provision. But the key caveat to it is that it's only applicable during occupation and times of military conflict. There are no international legal provisions protecting human groups that are persecuted within their own state. They were, in a sense, bubbled by state sovereignty. State sovereignty trumped the protection of human groups. So this was something Lemkin was very keen to rectify, and as I said, he recognised the sanctity of these groups. Lemkin saw human groups as an essential element of the world community, and if you think about it, in their destruction, the world community loses that something more that these human groups contribute. And as such, as Lemkin wrote, such destruction offends our feelings of morality and justice. So when it comes to answering the question, what is genocide, and understanding what makes genocide distinctive, I think Lemkin's clear. It's the destruction and subsequent loss of human groups. Now, although that in quite a general sense is the answer to what is genocide, there are multiple ways you can interpret genocide. And for the purposes of this, I haven't decided to engage in in-depth scholarly debate because I could be here for quite a while. But instead, I've adopted these two categories which were proposed by an academic, a legal academic called Anthony Dirk Moses. And I've put his article on the screen if anyone wants to take a picture and go away and read that. But Moses posits that there are two schools of thinking when interpreting genocide, the liberal and the post-liberal. You don't focus too much on the terminology, just suffice to say that there are two distinct groups. The liberal interpretation of genocide views human groups merely as a collective of individuals. So it looks at the group as a collective of that individual. And when you look at the group in that way, it can only be destroyed in one way, physically. So that could be through terminating the lives of members of that group through mass killing and other physical means, or through biological means. So, for example, reducing the birth rate of a human group. The post-liberal interpretation, which I might add is my interpretation as well, is that human groups are a composite of cultural structures and individuals, and as such they can be destroyed through various methods. So an example of this would be if a religious group, you are prohibited from exercising that religion, well, over time you may not immediately see the destruction of those people, but certainly generations down the line, if you have prohibited that religion, you will see that group be destroyed. And that does not involve any destruction in the physical sense, as the individuals will continue down the generations. So that is the key difference between the liberal and post-liberal interpretation. The post-liberal looks at an outcome. The post-liberal will say genocide is an outcome, it's a product. Has the group in fact been destroyed? Whereas the liberal interpretation will look primarily at the techniques of genocide and exclude any form of non-physical techniques of destruction. So it will solely rely upon mass killing and other biological methods. Now, the ultimate problem with the liberal definition, and this is something I'll come on to a bit later in more detail, is that when you focus on the physical techniques, namely how is a group destroyed rather than is the group destroyed, you then start to focus on the act, the perpetrator, and the intention of the perpetrator. And that's key when we come to considering the convention. And the one thing I would add is that when we consider actually which interpretation best reflects Lemkin, well, both schools of thinking will rely upon Lemkin as an authority, but I would argue that the post-liberal interpretation is the most representative of Lemkin. I mean, as I've already mentioned, Lemkin acknowledged this cultural aspect to groups, this sanctity of human groups and the techniques of destruction through both physical and non-physical means. But Lemkin's thinking was also derivative of colonization. So Lemkin was clear in his book, and he discussed it in Axis Rule, the effects colonization have had on human groups and how these have slowly and over time destroyed groups, something which would not necessarily be made out under the liberal interpretation. So having considered what is genocide as a concept, what did Lemkin envisage genocide to be, namely the destruction of human groups? How is that reflected in the convention? Ultimately, one of these two interpretations of genocide was going to be defined in law. And I think you can imagine from the way I've been leading into this that it was the liberal interpretation that is reflected in the Genocide Convention. Now, what I'm going to do now is I'm going to look briefly at some of the draft and the draft text, just so we can sort of see this idea of how it was developing into the convention we know today. So the drafting started really with Resolution 96-1. This was passed by the General Assembly of the UN, and it requested that the Economic and Social Council of the UN would create a report and define the crime of genocide. Now, importantly, Resolution 96-1 did give a preliminary insight into what the drafters were already thinking genocide was. So they defined genocide, and I've put it on the slide there. Genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. And then it goes on to talk about the cultural loss that would then ensue. Now, although this resolution is reflecting the general principle of genocide, namely the destruction of human groups, its reference to homicide shows that there is already this predisposition towards physical techniques of destruction, namely physical killing, and doesn't actually acknowledge that the group can be destroyed through cultural techniques. It does, of course, mention cultural loss, but this is more an observation of the effects of physical destruction, not necessarily saying the group can be destroyed through cultural means per se. Now, the Secretariat draft was the first draft of the convention, and this is compiled by the UN Secretariat with the assistance of 3 legal scholars, Henry Donadieu de Vabra, Vespasian Pella, and Lemkin. Now, when it came to, and I put the relevant section on the screen, when the 3 academics considered the question, what is meant by genocide, Lemkin posited that this can be broken down into 3 techniques: physical, such as mass killing; biological, such as the prevention of births; and cultural, such as the eradication of religion and other cultural means by which that group exists. And as you can see on the screen, at the outset of the report, the question was, should all 3 of these notions be accepted, or only the first, namely physical and biological? Well, as you can imagine, Lemkin was a strong advocate for all 3, as they, in his view, represented genocide. This was not the opinion of the other 2 experts. And on the screen, I've again got the relevant passage from that report, where the 2 academics saw cultural genocide, as it were, represented an undue extension of the notion of genocide. So from the outset, there was very little appetite to entertain cultural or non-physical techniques of destruction within the definition of genocide. And it does this frequently throughout the report. Indeed, when discussing acts of violence committed by individuals or communities, the draft notes that these would be outside the notion of genocide, where the intention to physically destroy the group is absent. And again, when discussing conditions that result in the debilitation or death of individuals, the draft describes this as a slow death, one where the intention of the author may be less clear. So we're starting to see already this significance and this emphasis on the intention of the perpetrator, rather than the question of, has this human group been destroyed by a perpetrator's actions? So again, and on this slide as well, it does talk about genocide being the deliberate destruction of the human group. So you're seeing this as an intentional, purposeful act by a perpetrator. And ultimately, there was much debate amongst the parties about how to define genocide, but the idea that cultural genocide should be represented in the convention was simply not acknowledged widely by the drafting parties. And as such, the convention finally defines genocide as I've put on the screen. Now, it's useful to look at this definition in, again, 2 parts. The first is, has the perpetrator committed any of those acts outlined at subparagraphs A to E? So, for example, mass killing, causing seriously bodily or mental harm to members of the group. If the answer is yes, then you've satisfied what in law is considered the actus reus, namely just the criminal act. You then have to turn to the intention, and this is where the focus of at least tonight's talk will pay attention. And that is, in committing that genocidal act, have you done so with the intention to destroy, in whole or in part, a national, ethnical, racial or religious group as such? So, for example, if you were found that you have killed members of that group on a mass scale, but were indifferent to the outcome of that killing, you would not have committed genocide under the Genocide Convention. It is insufficient that the perpetrator had knowledge that in undertaking their criminal acts, they would have destroyed the group, because that was not the purpose of their actions. The Genocide Convention has an exceptionally high threshold that those actions must be committed with the purpose of destroying the group in whole or in part. Now, the practical and inevitable consequence of this we've seen in its recent application. So, for example, if you are to infer intent, which I might just add, all intent has to be, if you think about it, the only person that has knowledge of a perpetrator's mental state is the perpetrator. There's no other way of knowing what their mental state was. So for courts and tribunals to consider whether or not this mental element is met, they must do so based on evidence of actions, usually, to make an inference. Now, if a genocide is widespread, if it's systematic, if it's planned, if it's documented, you are more likely to be able to satisfy that criteria, because you're more likely to be able to make that inference. But if a genocide is smaller scale, if it's not as widespread, if it's unplanned, it will simply go unrecognised as genocide under the Genocide Convention. And this was the case in Darfur. So on the screen, I've put the relevant section of the report. This is just part of the summary. And if you'd like to read more, I would recommend reading the report. You can find the full report online. But the Commission concluded, in respect of the Sudanese government, that they had not pursued a policy of genocide. And they went on to conclude that the crucial element of genocidal intent appears to be missing, at least as far as the central government authorities are concerned. And this was in spite of genocidal acts being found to have been committed. And as such, the Commission concluded that genocide had not occurred. Now, for me, this is one of the fundamental failings of the Genocide Convention. It is so restrictively drafted that it inhibits instances of genocide being recognised as such. It means that perpetrators, quite simply, are not held responsible for their genocides, and the obligation to prevent genocide under the Convention does not arise. So states are not obliged to prevent instances of human group destruction without an intent to be found. Now, rather than just looking at quite generally where we lie with the failings of the Convention, I'd like to turn to its application, because I think when we look at the way in which specific intent has been played out within courts and tribunals, and actually seeing how it's been applied, we really start to see in the detail where the Convention is lacking. Now, although the Convention came into effect in 1951, it wasn't really applied until the 1990s with the ad hoc tribunals for Rwanda and the former Yugoslavia. Now, for tonight's webinar, I can't look at loads of cases, but I have selected two from before the ICTY. And these rely on the cases of Momcilo Krajnik, who was part of the Bosnian Serb leadership. He was also president of the Bosnian Serb Assembly, and Radovan Karadzic, who was the president of the Bosnian Serb Republic. So both of these men were senior leaders in the regime. Now, both men were faced counts of genocide. Both were found guilty, except for Karadzic, who on one count was found guilty. I don't know, I can't remember what I said, but not guilty, with the exception of guilty for Karadzic. So turning first to Momcilo Krajnik, as a senior member of the Bosnian Serb presidency, he was charged and found guilty with 6 counts of crimes against humanity and war crimes. Now, as you can imagine, Krasniq, like most senior leaders in instances of genocide, didn't personally commit those genocidal acts. So he personally didn't commit any killing. But they looked at ICTY approached this as part of what they called joint criminal enterprise. So it was this idea that to establish someone's liability, you look at the crimes as part of a wider enterprise and ask yourselves, actually, what was the involvement of this individual within that enterprise? So you were looking at the enterprise as a whole. Now, Krasniq was found not guilty on the counts of genocide on the basis that the objective of this joint criminal enterprise did not meet the genocidal intent or specific intent requirement I've just mentioned under the convention. Namely, they were satisfied that the overarching objective of the joint criminal enterprise was to ethnically cleanse Bosnia-Herzegovina, but they were not satisfied that that ethnic cleansing included the intention to destroy the Bosnian Croat and Bosnian Muslim groups as such. Now, the reason this judgment is quite telling is because it highlights something what some academics refer to as genocidal double rhetoric, and it's this idea that perpetrators can conceal their actions and genocides based solely on how they frame it. So, for example, on the 12th of May 1992, following a speech by Radovan Karadzic in the Bosnian Serb Assembly, Genro Mladic expressed practical concern over how Radovic was planning on executing this regime of genocide. Indeed, he went on to say, I don't understand how you don't recognise that that would be genocide. Now, what Mladic did was, rather than say, no, we ought not to do it, that would be atrocious to do, instead, Mladic stated in a speech exactly how they should frame their actions so as to avoid international attention and avoid a finding of genocide. And on the screen, I've quoted the relevant passage from the judgment. Mladic said, we should not say we will destroy Sarajevo. We need Sarajevo. We are not going to say that we are going to destroy the power supply pylons or turn off the water supply. No, because that will get America out of its seat. But one day there is no water at all in Sarajevo. What it is, we do not know. And at the same time, with the electrical power, we have to wisely tell the world it was they who were the shooting, hit the transmission line and the power went off. They were shooting at the power supply facilities. That is what diplomacy is. Now, although the ICTY actually quotes this speech within their judgment, they do so only to show Krasniq's military knowledge, so his knowledge of the military operations at the time. Indeed, the tribunal say that what Mladic was proposing wasn't genocide, but an alternative to genocide. So what we see here, crystal clear as an example, is that perpetrators, and this is the bit that's most troubling for me, are given control. We give perpetrators control over when their genocides are recognised as genocides, because they are given the control with how they present that genocide to the world. We are not asking the question, has the human group been destroyed? We are approaching it through the eyes of the perpetrator. Turning now to Radovan Karadzic, and as I mentioned, Radovan Karadzic was president of the Republic and supreme commander of the armed forces, so he was the most senior person within the Bosnian Serb Republic. Now, as such, he faced 11 counts and he was convicted guilty on 5 counts of crimes against humanity and 4 counts of war crimes. He was charged on 2 counts for genocide, and these were separated into the genocides committed throughout the municipalities, the different areas within Bosnia, and count 2 referred to the genocide in Srebrenica. Now, Karadzic was only found guilty in respect of the genocide in Srebrenica, not the genocides throughout the municipalities. And the reasons for this are quite stark when you get into the detail. So, turning first to the first count in which he was found not guilty for the genocides in the municipalities. So the trial chamber was satisfied that genocidal acts had occurred, and there was much evidence of mass killings, mass shootings, rapes, concentration camps, and so forth. And they were satisfied that these met the criminal acts required under the convention, but they were not satisfied that the intention to destroy the Bosnian Muslim and Bosnian Croat groups as such was made out. Indeed, as I've put on the screen, and I've highlighted the relevant section from their conclusions on this count, that they are unsatisfied that an intent to destroy the group was met, but rather there was an intent to create an ethnically homogenous Serb state, to separate the Bosnian Muslims and Bosnian Croats and remove them from Bosnian Serb-controlled territory, but that this did not equate to an intention to destroy. Now, the reason I find this so troubling and the reason it's so stark when we look at the convention is that throughout the municipalities, Karadzic was found guilty for extermination as a crime against humanity. Now, extermination in law is substantially similar to genocide in the sense that it has the self-same consequence, namely the destruction of a group. Extermination is defined as the annihilation of a mass of people, and to be convicted, you have to satisfy that the perpetrator had knowledge that his actions are part of a vast murderous enterprise in which a large number of individuals are systematically marked for killing. Now, the ICTY was able to say that those criteria was met, namely that the extermination is an annihilation of a mass of people, and that Karadzic had knowledge that this was happening. But because of the exceptionally high threshold within the Genocide Convention, this would not be recognised as genocide. But if we think back to what Lemkin defined genocide as, this is undeniably genocide. Now, turning to the second count, there we go. So this was very similar to the first count on the basis that they were satisfied genocidal acts had occurred, but in this instance, they were satisfied that there was an intention to destroy the Bosnian Muslim group as such in Srebrenica. And the reason for this is based on the way it was conducted, not the impact, not the outcome, not whether or not the group was destroyed, solely on how that genocide was conducted. And indeed, at the highlighted sections of that judgment, the Chamber speaks of how it's satisfied beyond a reasonable doubt that these killings were carried out pursuant to a systematic and highly organised plan. They then talk about how the plan then came to encompass the killing of all Bosnian Muslim males in Bosnian Serb custody. So the basis of this is that it was planned, and as such you can infer genocidal intent, and that is solely a consideration on the way a perpetrator destroys a group. So, but the one thing I would add in this, which I do think is key, is when you do read this section of the judgment, a lot of reliance was placed on a phone conversation between Karadzic and senior military leaders, in which they spoke of this operation in code. And the tribunal said, well, this is an example of malign intent, and as such, we can then make that inference. But what if, which I have posited in academic work, what if there was no evidence of that conversation? What if this plan was not clear in evidence before the tribunal? What if many of these factors from which Karadzic spoke about, and he explicitly said what the Bosnian Serbs were trying to do, what if none of these were presented before the tribunal? Does that mean genocide would not be found in Srebrenica? The short answer is, yeah, genocide would not have been recognised in Srebrenica, despite the fact that nearly 9,000 Bosnian Muslims were killed in that area. Now, I'm conscious of time, I'm just coming up to 40 minutes, so I'll leave this section. I may be able to return to it in questions, but I am very keen to take questions and to hopefully open up a dialogue about this. So I'll stop sharing my screen now and invite any questions you may have.
I have a question. Surely it's in line with English law, where for murder you need mens rea, whereas if you don't have the intent, or if it can be shown that you didn't have the intent, then it may be manslaughter, but it certainly isn't murder, in which case it would seem that that's a parallel.
You can't hold that though.
Yeah, so there is a parallel quite a lot to English law, murder and manslaughter. And actually this does lead me on to the last section of the PowerPoint, which is about reform. So you are right, in English law, not only do you have to kill someone, so you've got that homicide element to it, but you must do so with an intention to either kill that person or cause GBH. What you can do in international law, which is what I would recommend as a proposal, which would keep that mens rea element, so that intention element, but lower the threshold. So, and that is through what's considered a knowledge-based approach. So at the moment, you're looking at the purpose of these actions rather than their outcome.
Not a podcast.
Go to a knowledge-based approach.
Could somebody mute themselves, because I'm trying to listen to Joe and I'm getting
feedback. Is everyone on mute? I think so. Yeah. And what you would have is a knowledge-based approach. So what you would ask is, has this genocidal act been committed? Yes. Did the perpetrator have knowledge that their actions would lead to the destruction or a real risk of the destruction of a human group? And that wouldn't be novel in international law. That is currently the threshold for crimes against humanity. You just have to have knowledge that your widespread or systematic attack will lead. You do not need that specific intent. So this is something that's exclusive to genocide. But the one thing I would add, and why I caution against specific intent, and it's likeness to murder within English law, is within English law, when you look at murder, you are very often looking at an isolated example of one action. Usually if it's multiple murders, you will be able to look at that, but usually have one perpetrator and one killing. With genocide, practically, that's not possible. And the victim group is usually quite wide. So if you start to look at individuals and start to look at, well, did this, say, one perpetrator have a specific intent in killing these three people, the courts would not be able to cope. And you're looking at individual instances, whereas what genocide is fundamentally about is the group as a whole. So if you want to look at the group as the victim of genocide, I think that knowledge-based approach is not only adequate, but I actually think that you would get the objectives of the convention better met than you currently are. Does that answer the question?
Yes. Could I ask you a supplementary to that then? Crimes against humanity, the different one, does that require intent?
It does. But at the moment, actually, I'll just pull my slides back up because I have got the definition on the slides, just so everyone can see. Yeah, there. So crimes against humanity. So it's any of the following acts, and they're quite vast, they're listed there. If it's committed as part of a widespread or systematic attack against a civilian population, a perpetrator would be liable if they have knowledge of the attack. So that's the mental element you're looking for. Did that perpetrator have knowledge of that widespread or systematic attack? And the reason being is that, for example, if you were in a military conflict and a soldier was to murder 2 civilians, but did not have knowledge of that widespread or systematic attack, it may well be a war crime, but it wouldn't necessarily be a crime against humanity. Yeah. But if in murdering those 3 people, that soldier knew that their attack was part of a widespread or systematic attack against that population, they would then be liable for crimes against humanity. The key difference between crimes against humanity and genocide is